Good morning and welcome to this webinar of the Information Regulator that will be specifically dealing with the whole aspect regarding prior authorization. But before we kick off, I would like to request our chairperson, Advocate Pensi Tlakula, to give an introductory note for this session. Over to you, Chair.
Thank you very much, and good morning to everyone. My name is Pensi Tlakula. I'm the chairperson of the Information Regulator. Let me start by welcoming everyone to this webinar and greet all of you from a gray and cool Johannesburg. We are pleased that you have heeded our invitation to this webinar. I am accompanied here by one of my colleagues, a member of the regulator, Professor Sizwe Snail, who spoke before me. And we also have a number of executives who have joined the webinar. We have Advocate Dironso Mohali, who is the newly appointed executive for POPIA. We have Mr. Nzumbezeni Nemasisi, who is known to most of you. He's the executive for PAIA. And then we have Ms. Vasha Sulal, and you know her as well. She's been with us for some time. She is the executive for legal, policy research, and IT analysis. And we have Mr. Mukelani Dimba, who is the executive for education and communication. Those of you who have worked with us this journey for the past few years, you will know that we started the organization just being the five of us as members of the regulator together with one or two executives. You will see that we are growing. We now have a full complement of executives and we have a full complement of senior managers. So we have been hard at work building these organizations, and the fruits of our labor are beginning to bear fruit. With that having been said, we thought we should organize this webinar in the spirit of assisting our responsible parties with trying to interpret or with the interpretation of the sections that deal with the applications for prior authorization. Why we decided to convene this webinar is because we have received a large number of applications for prior authorization. At last count, we had more than 300. You will recall that Section 58 that deals with prior authorization was supposed to come into effect on the 1st of July this year, but due to a large number of applications that we had received at that time, we then decided to postpone the coming into operation of that section to the 1st of February, 2022. The applications are coming thick and fast. We're trying to keep up with them, but we realize that most of the responsible parties who have applied for prior authorization are not processing personal information that require prior authorization. We are mindful we are aware why responsible parties have decided to apply for prior authorization, because they do not want to find themselves on the wrong side of the law. So they thought that maybe let's just put in our applications whether or not we need prior authorization, so that the regulator should be the one who should then advise whether they need prior authorization or not. But obviously, because of the large number, that takes a long time, a lot of energy for us to go through all the applications for prior authorization. At the moment, we have already realized that most of the responsible parties that have applied for prior authorization do not actually need prior authorization. They do not process personal information that requires prior authorization as stipulated in section 57 and 58 of POPIA. So really, that's the purpose of this webinar. And we hope that at the end of this webinar, the responsible parties that have applied for pre-authorization and who have attended this webinar will be able to decide for themselves whether they process personal information that requires trial authorization. And we hope that after making that analysis, they will then hopefully withdraw their applications so that we are left with a few applications that from the responsible parties that really need prior authorization. So how this is going to work today, our executives are going, or one of them is going to make a presentation once again on prior authorization, because you'll recall that earlier this year we published a guidance note on prior authorization, which we thought would assist responsible parties with the interpretation of the requirements required, or the requirements for prior authorization. But obviously we do see that there are still some gaps. So our executives will assist you with the interpretation of the relevant sections, the interpretation of the guidance note, and what is required in terms of that guidance note. So please feel free to ask questions that you have, so that at the end of this, we are able to then move forward. With those few words, I would like to once again welcome you. And I also have to apologize that because I have another commitment, I will have to leave. But our executives really are best placed and will be able to deal with this subject matter, and they will also be able to respond to all the questions that you will have. Thank you very much, and once again, welcome to this webinar. Thank you, Professor Snee.
Thank you very much, Chairperson. Those were some introductory words from our Chairperson, Advocate Kakula, basically setting out the tone and the reason why this webinar has been created today. Just from the audience perspective, I'd like to encourage everyone to use the chat box if they have any questions, so that we can interact with those particular questions. And yes, I guess it has been a long time coming. The aspect of prior authorization has been a lot of confusion in the industries as to what exactly prior authorization is about. And as Chairperson said, the purpose of this particular webinar is to demystify the whole issue of prior authorization. So our next presenter will be Mr. Ntumbedzeni Nemasisi. He is our executive from the Information Regulator, who will be presenting the first presentation on behalf of the regulator. Mr. Nemasisi, are you there?
Good morning, Prof, and good morning,
awesome,
everyone, especially the chairperson of the Information Regulator. And good morning, colleagues.
Let us not waste any further time. Over to you, Mr. Nemasisi.
Thank you, Prof. And good morning, everyone, again. The presentation, obviously, I do not want to waste much time on my presentation, because some of the issues we'll discuss them during the questions and answer sessions. I've got a short presentation, and the topic for the presentation in the next slide. We'll have introduction. We'll also deal in the topic with the processing subject to prior authorization. I've seen one of the questions from the participants as to, will we deal with whether what kind of processing are subject to processing? We will do so. We will also provide practical example to that. We're also going to deal with the notification of processing, which is subject to prior authorization. We'll deal with the suspension of processing of personal information subject to prior authorization. We'll also deal with the manner of submission of an application for prior authorization. And we'll deal with the timelines for processing the application for prior authorization. In other words, how long should the regulator take to process the application for prior authorization? We'll also deal with the criteria which the regulator used in processing the application for prior authorization. We thought in order to ensure transparency, we need to then share this process with the participants. We'll also highlight the offenses and penalties for non-compliance with the requirement for complying with section 57, 58 of POPIA. In other words, if there's non-compliance with the prior authorization processes, what are the offenses and what are the penalties that are likely to be imposed? And we'll then conclude the session going to the question and answer session. And as you know, the protection of personal information aims to promote the protection of personal information. POPIA aims to promote the protection of personal information processed by the public and private bodies by, amongst others, introducing the minimum requirements for the processing of such information. And these are the 8 conditions for lawful processing of personal information. The 8 conditions, as we all know, those are the cornerstone of our POPIA. Without complying with them, it means you're actually in breach of the legislation of POPIA. So the information regulator is, amongst others, empowers to monitor and enforce compliance by public and private bodies with the provisions of POPIA. Next slide. So if you look at section 57 of POPIA, it requires public and private bodies, and those are we call responsible parties, which intends to process certain categories of personal information classified as high-risk processing or processing that carries a particular risk, to obtain an authorization from the regulator prior to such processing. So currently, there are only 4 categories of high-risk processing of personal information in which prior authorization is required, although the regulator may, in terms of section 57.2 of POPIA, require prior authorization for processing that carries a particular risk to the legitimate interest of data subject. At this stage, the regulator has not determined any particular processing that carries a particular risk, but once that is done, it will be communicated to the public for them to understand which other category that has been considered to be required for prior authorization. So a responsible party must obtain prior authorization only once, except where the processing departs from that which has been authorized by the regulator. In other words, if you apply for prior authorization for processing personal information and the regulator approves that application, you do not have to apply for prior authorization whenever you want to process personal information. That application is granted for life, unless you have got your processing has now departed from the one which has been approved by the regulator. But also, the legislature have realized that the processing which is subject to prior authorization may actually be applicable to the majority of the responsible parties. And they then have sections, instead of section that requires, in terms of which the prior authorization would not be required if a code of conduct has been issued by the regulator and has come into force in a specific sector, industry, or section of society in which the responsible party operates. So in other words, if for example, I'll take an example of the credit bureau industry. If a code of conduct is issued in that industry, all the registered credit bureau that create credit reporting will not have to apply for prior authorization because the code of conduct will be the one regulating that processing. And that's the main reason why the legislature inserted that provision that if a code of conduct is issued, you don't have to apply for prior authorization. And that's mainly because they were aware that there would be a lot of people who may have to apply for prior authorization. In order to cap that number, obviously the code of conduct, one code of conduct will actually limit the number of applications that may be processed. Next slide. So we now deal with the processing. What are the processing that are subject to prior authorizations? So as I indicated earlier on, there are 4 categories of high-risk processing of personal information which prior authorization must be obtained. And this it doesn't matter whether you comply with all 8 conditions. As much as you process this kind of processing of personal information, you have to apply for prior authorization because they are categorized as high-risk processing. And the first one will be where you're processing a unique identifier of data subject for a purpose other than the one for which the identifier was specifically intended at collection, and with the aim of linking the information together with the information processed by other responsible parties. I will give a practical example later on as to practicalize this processing so that the responsible party may have a better understanding what it means when you say processing a unique identifier of data subject for a purpose other than the one for which it was specifically intended at collection. But what are the unique identifier? For example, those are the ID number, account numbers, or policy numbers. So unique identity number is, for example, if you take my ID number, you put it into the system of the bank. Immediately when you put my ID number, all my information will come out. And that's why they call it, it's a unique identifier. So once you process it, you'll be able to access all the personal information of the person. And if you give the account number, that's the same way. And that's how we categorize them as unique identifier. But I will give a practical example of this processing so that the responsible party can have a better understanding. You can move to the next slide. The other processing, which is subject to prior authorization, it's a processing of personal information of data subject on criminal behavior or unlawful objectionable conduct on behalf of a third party. So it means if somebody is conducting a criminal check on behalf of the employer, I'll give a practical example as well with regard to that, but such processing is subject to prior authorization. And the third one is processing of personal information of data subject for purpose of credit reporting. This is applicable to the credit bureau industry. We'll deal a practical example as well with regard to that. And the last one, this is the most critical one, is the transfer of special personal information or the transfer of personal information of children to a third party in a foreign country that does not provide an adequate level of protection for processing of personal information, as referred to in section 72. One of the questions obviously would be what information constitute a special personal information? These, for example, are your religious or philosophical beliefs, your race, or ethnic origin, your trade union membership, your political persuasions, health or sex life, or biometric information, or criminal behavior relating to the alleged commission of offense. Those are categories of special personal information, which if you intend to transfer them to another country that does not provide adequate level of protection, you have to get a prior authorization from the regulator. Currently, the regulator has not conducted an adequacy level of which country has got an adequate level of protection of personal information. We have not done so, but it's something that we'll consider in the near future. But at this stage, obviously, the responsible party will have to do such kind of an assessment in the meantime, while the regulator will consider as to by when we'll be able to conduct that adequacy assessment of the countries which may provide adequate protection or may not provide adequate protection. But that has not been conducted yet, but something that the regulator will consider in the near future. Thank you, Mr. Dimba. So I'm going to give now a practical example of those 4 categories of processing which is subject to prior authorization. The first one, like I indicated earlier on, is the one in which the processing of unique identifier of data subject for a purpose other than the one in which the identifier was specifically intended at collection, and with the aim of linking the information together with the information processed by other responsible parties. The practical example is that you've got ABC company, which, for example, might be a financial service provider. It collects an ID number of a data subject, which is our ID, me and you, our ID number for purpose of providing credit. So that's purpose A. So when you apply for credit at the bank, the purpose of you providing your information, your ID number, it's for credit, for you to obtain credit, and that's purpose A. But what then happened, the responsible party, which means the bank, they'll take your ID number, they'll link it with the information processed by other responsible party. And who's the other responsible party? Is the credit bureau. So they take your ID, link it with the information that is stored by the credit bureau. And that's for purpose of checking your credit record, your credit status. And that is the purpose B now, which is the purpose in terms of which they want to check your affordability of assessment. So you've got purpose A, for which you submitted your ID number, and then the responsible party then take your ID number for purpose, obviously provided for purpose A, which is the credit, and then they link it with the information processed by the credit bureau for purpose B, which is to check your affordability so that they can then decide whether they should grant you a credit or not. So such a processing is subject to prior authorization. Other people may say, but there's no way that a bank can grant you credit without checking your credit record. Yes, indeed, it's true. There is no way that they can grant you credit without checking that. And that's where it goes into the third stage of assessment, which is the compatibility of the assessment. So the compatibility of that processing is the one that will check towards the last stage of assessment as to whether such conduct of taking my ID number, linking with the information the credit bureau, does it comply with the is it compatible with the original purpose? And this is one of the conditions that you have. And therefore, if it's compatible, in this example, it is compatible and therefore is the ground upon which the regulator must grant the prior authorization. I hope this example clarifies. The next one is the one in which the processing of personal information of data subject on criminal behavior or unlawful or objectionable conduct on behalf of third parties. The practical example here is that you have an ABC company that intends to appoint an employee, but such appointment is subject to criminal or background checks. So the DEF company, which is the other company, is therefore appointed by ABC company to conduct criminal behavior and background checks on behalf of ABC company. And so ABC company in this instance, which is the company that intends to employ a person, it's a third party, and DEF company is the one which is conducting that background and criminal check. It's the company that's supposed to obtain prior authorization from the regulator in respect of such processing. And therefore, ABC company must, prior to appointing the DF company, verify if DEF company is duly authorized by the regulator. So in other words, as a responsible party, if you intend to appoint an employee, but you want to check the criminal record, the background check about their previous conduct, and you appoint a company to do such on your behalf, that company must have obtained prior authorization for it to conduct such search. And it is the responsibility of the responsible party to ensure that that company is actually registered, authorized by the regulator to do so before appointing them, and they need to obtain that prior authorization. The next slide. The next one is the one in which processing of personal information of data subject for the purpose of credit reporting. And I'm sure Advocate Mohale will touch on this. One of the challenges that obviously will come in is it's when you've got a company that does not provide credit reporting, or even a bank apply for prior authorization under this category. So this category is ABC company, for example, which is, for example, you know, our biggest credit bureau will be your Experian, your TransUnion, your Very Credit, or XDS. These are registered credit bureau. And they process personal information for credit reporting. And the credit reporting refers to processing of personal payment history, lending, credit worthiness of a data subject by creating a credit report. And this is the critical one. So you must be creating a credit report based on that information. And lenders or credit provider use the credit report along with other personal information to determine the data subject credit worthiness. So in other words, if you are a credit bureau that therefore you create a credit report that is being used by the lender's credit provider in searching for the credit worthiness of data subject, as a credit bureau, you therefore have to register to obtain a prior authorization from the regulator unless there's a code of conduct issued. At this stage, we can confirm that no code of conduct has been issued by the regulator, and therefore those credit bureau companies will have to apply for prior authorization to the regulator so that they can be able to proceed with the processing. Then the credit provider or resellers, we can go back a little bit, my apology about that. So the credit provider or resellers of credit bureau, this is, for example, if I were to give example, your LexisNexis risk management companies and your Credit It, they do not have to apply for credit for prior authorization. That's because they do not create report. They resell the credit report. So if you're not creating the credit report and therefore you do not have to apply for prior authorization because you're a reseller, it means somebody else created the credit report and then all you do is to resell that information. So you are not following under that processing that in which prior authorization is required as a reseller of the credit report. I'm sure you have heard about the Clear Score as well. They might be registered as a credit bureau, but they're actually not creating, they don't have their own report. They resell the credit bureau from other credit bureau. You can move to the next slide, Mr. Dimba. So the last one is the transfer of special personal information or personal information of children to a third party in a foreign country that does not provide an adequate level of protection. So the practical example on this one is that you have got ABC company, which is an international company operating in South Africa and other several countries. And some of those countries in which special personal information or personal information of children may be transferred does not have the privacy laws that provide an adequate level of protection for the processing of personal information. As a result, the ABC company must apply for prior authorization in respect of intended transfer of those special personal information or personal information of children that in those countries that does not provide adequate level of protection. I've indicated earlier on that the regulator have not conducted an assessment on adequacy of any other countries in terms of which can assist the responsible who intend to transfer the special personal information or personal information of children to check whether those countries does provide adequate level of protection. In this instance, some people may come and say, but if you look at section 72, what do I have to apply for prior authorization if I intend to transfer this personal information to a country that does not provide adequate level of protection, but the data subject has consented? For example, the data subject, this will be in the interest of the data subject. There's a clear benefit to the data subject, or we do have an agreement that provides for adequate level of protection. Yes, you have to apply because that processing of transferring to that particular country has been categorized as the requirement, as one of the processes that require prior authorization. And the fact that there's a consent or there's a clear benefit to the data subject, it's a ground upon which the regulator will then grant you an authorization to process. So the fact that you've got consent or there's an agreement that regulates and provide adequate protection, that's a ground upon which the regulator will then consider granting you an authorization to process or to transfer such special personal information or the personal information of children in another country. Can move to the next slide. So those are the four categories and practical examples that we managed to put forward to assist. The next one is the notification of processing, which is subject to prior authorization. And so you know that in terms of section 58, a responsible party who intends to process personal information which is subject to prior authorization, and those are the one that we have indicated earlier on, is required in terms of section 58(1) of POPIA to notify the regulator of intended processing. So in other words, if you intend to process any of those categories that I've mentioned earlier on, you have to notify the regulator that you intend to process personal information. But what the regulator did to simplify the process, we have included the notification in the prior authorization application form. And there's no need for a separate application form from the application for prior authorization, unless the said responsible party does not intend to apply for prior authorization. In other words, once you know that you actually process personal information that is subject to prior authorization, there is no need for you to have a separate notification to the regulator. By completing an application form for prior authorization, you are actually notifying the regulator simultaneously that you intend to process those personal information. And that would be, so if you complete the application form, you are actually notifying the regulator. So there's no need for you to then notify the regulator that you intend to apply, and at the same time also complete the application for prior authorization. The application form has covered both instances of notification as well as the application instances. Can move to the next slide. Then the next issue that we deal with is the suspension of processing of personal information subject to prior authorization. You remember Chairperson dealt with the effective date of section 52 of POPIA. This section provides that the responsible party may not carry out information processing that has been notified to the regulator in terms of section 58(1) until the regulator has completed its investigation or until they have received a notice that more detailed investigation will not be conducted. In other words, once you notify the regulator, and if Section 58.2 has come into operation, you will have to suspend the processing of personal information until such time the regulator completes its investigation or the regulator has actually indicated that it will not conduct a detailed investigation. However, because the Section 58.2 has now is not effective, the regulator determined the effective date of Section 58.2 to be the 1st of February 2022. That's the date in which the Section 58.2 will come into operation. In other words, at this stage, any processing that's subject to prior authorization, you do not have to suspend the processing while the regulator is processing application. It means the responsible party will still continue processing personal information subject to prior authorization, obviously in compliance with all the 8 conditions. You need to comply with all 8 conditions as you process those personal information that is subject to prior authorization. There's no need for suspension of processing because Section 58.2 will only come into operation on the 1st of February 2022. What does that mean? It means on the 1st of February 2022, if you have not been granted authorization and the regulator have not finalized the investigation, you will have to suspend the processing. Or if you bring an application, say in January, and at that point, the regulator will not have finalized the processing, unfortunately, you will have to suspend the processing of personal information at that stage. So we are actually encouraging the public to responsible parties to submit the application at this stage now so that the regulator can have sufficient time, which I'll deal with it later on, to process those applications. By the 1st of February 2022, we should have given you the decision as to whether authorization is granted or not. And that will be a smooth transition with regard to not hamper your processing as a responsible parties. Next slide. Then the manner of submission of an application for prior authorization. So we need to highlight as to how is it that you can submit your application for prior authorization. So the prior authorization application or notification for processing or intention to process personal information, as referred to in Section 57 and 58 of POPIA, must be submitted to the regulator through the following channel. You remember in the past, we had a dedicated email address for prior authorization. The regulator, as the chairperson has indicated, is actually growing. We are actually in the near future going to be having our own website. So we also, in preparation for that, we started to have our own email addresses. You remember in the past, we were relying on justice with regard to the email addresses, which resulted in most of the time their emails being down, and as a result, we're unable to access the emails. We now have our own email addresses. So those applications for prior authorization must be sent by email to POPIA compliance@informationregulator.org.za. These emails are actually publicized in our website. If you go into our website now, you'll be able to see the other email addresses that we have that you need to submit other applications. But for purpose of prior authorization, this is the email address where the application can be sent. We do also receive application by post, and this is the postal address, as well as can be delivered at our offices. These are the new offices at JD Houses in Braamfontein. These are our new offices where you can submit an application. Obviously, due to COVID, we do encourage application to be submitted by email so that we should not transmit the virus. If the application is submitted, obviously, when you compile those documents, put them together, we do not know, we're not scientists, but we're just trying to encourage people to submit applications by email, and so that we do not transmit, avoid the transmission of the virus through the manual submission of those applications. If you can go to the next slide, Mr. Dimba. Earlier on, I indicated about the requirement of responsible parties to then submit the application earlier in time so that it can allow the regulator sufficient time to process those applications. So we're going to deal with the timelines. What are the timelines for processing those applications for prior authorizations? Next slide. So the first timeline is that the regulator may approve or reject an application for prior authorization within 4 weeks of receipt of application for prior authorization. unless the regulator decides to conduct a detailed investigation. This means that if we receive an application for prior authorization, we've got 4 weeks to make a decision whether to grant it or not. And unless there are some other information that we may need, which was not part of the application, and we decide to conduct a detailed investigation. And in the event that the regulator decides to conduct a more detailed investigation, the regulator will inform the responsible party in writing of the reasonable period within which it plans to conduct a detailed investigation, which period will not exceed 13 weeks. In total, the regulator has 3 months to complete detailed investigation. So we will inform you once we have, but this time frame now do not affect them, are not necessary for at this period. They are not that important because the suspension, because of the suspension of the effective of Section 58.2. In other words, because you do not have to suspend your processing of personal information. These timeframes are not that significant at this stage. But from the 1st of February, the timelines will be very important because immediately once you submit an application, you need to suspend the processing that is subject to prior authorization. Let's move to the next slide. The question that most of the responsible party may have is that what are the criteria that the regulator use in processing the application for prior authorization? We have established about 3 kinds of stages in which an application for prior authorization will be processed. Can move to the next slide. And the first stage of assessing the application is we check whether that application falls under any of the exclusions in terms of Section 6 and Section 7. If you look at Section 6 and 7 of POPIA, it provides for exclusions. In other words, for processing of personal information, which is excluded from POPIA. So the first stage of assessment of the application is whether your processing falls under any of those stages. And if it doesn't, then we move to the stage 2. Stage 2, that's where we determine whether processing is subject to the scope of prior authorization under Section 57.1. You remember the 4 categories of processing that's subject to prior authorization. This is where we check whether indeed you are required to apply for prior authorization or not. And if we determine that indeed you are required to apply, your processing falls under any of those processing of personal information that is subject to prior authorization, we then move to the next stage of assessment. This is the most critical stage of assessment. This is where we check if such processing is compliant with the 8 conditions for lawful processing of personal information. You will notice that in terms of the guidance note that we've issued in the application form that we've issued, we did not require you to submit information on other conditions except the one for security safeguard. And that was an oversight. The guidance note is being reviewed. And now what we do, you will receive communication from our investigators, the people who will be conducting an assessment on your application, to provide additional information regarding the other 7 conditions that you may not have submitted. Can move to the next slide. So the issue that we contend about is that what are the offenses and penalties for non-compliance with the prior authorization requirement? So there is offenses for failure to notify processing subject to prior authorization, which provide that the responsible party who fails to notify the regulator of any processing that is subject to prior authorization in terms of Section 58.1 of POPIA is guilty of an offense. So if you do not notify the regulator that your processing is subject to prior authorization, that is an offense. And also, responsible party who has notified the regulator in terms of Section 58.1, but it does not suspend processing, then in other words, they carry out processing of personal information before the regulator complete the investigation by the regulator is completed, or before receiving any notice that a more detailed investigation will not be conducted. Such conduct is an offense in terms of POPIA. So if you notify the regulator and you do not suspend, such is an offense. But at this stage, I must qualify, it is not an offense because the Section 58.2 has not come into operation. In other words, you are not required to suspend processing that is subject to prior authorization at this stage until the 1st of February 2022. But from that period, if you have applied, you have submitted an application and you do not suspend, you do not suspend processing, such will be an offense. We'll share with you the penalties for that. The penalties for failure to notify processing subject to authorization. So any person convicted of an offense for failure to notify the regulator of any processing that is subject to authorization, or who notify the regulator but carry out such processing, it's actually such processing before the investigation by the regulator is completed. Such shall be liable to a fine or to imprisonment for a period not exceeding 12 months, or to both a fine and imprisonment. Because it's an offense, therefore, the criminal case will be opened, and the magistrate or the judge deciding on those matters will decide whether to impose a fine or to impose an imprisonment, or to impose both fine and imprisonment. Obviously, the question that people may ask is that, but how would you imprison a responsible party, a company? There is obviously a person who's be held accountable, and the first suspect will be the information officer of that company, or any person who will have been responsible to breach the requirement of POPIA, and that's the person who will go to prison. But in terms of the fine will be imposed against a responsible party, unless the court determines otherwise. The other offenses and penalties for failure to comply with a statement concerning the unlawfulness of the information processing. So the decision of the regulator following a detailed investigation will be issued in a form of a statement concerning the lawfulness of the information processing. In other words, if the regulator decides to conduct a detailed investigation, the regulator will issue a statement, and that statement will then indicate whether the lawfulness or unlawfulness of that processing. Should the regulator find that the information processing is unlawful, such statement by the regulator shall be deemed to be an enforcement notice served in terms of Section 95. In other words, if you are making an application to the regulator for prior authorization, and the regulator decides to conduct a detailed investigation, after conducting detailed investigation, realize that actually your processing does not comply with any of the conditions for lawful processing of personal information. In other words, your processing is unlawful. Such statement issued by the regulator that will be given to the responsible party who applied for prior authorization, it's regarded as an enforcement notice in terms of Section 95. And the responsible party who fails to comply with enforcement notice will be guilty of an offense and shall, upon conviction, be liable to a fine or to imprisonment for a period not exceeding 10 years, or to both such fine or such an imprisonment. Next slide. So in conclusion, currently the regulator has actually completed the investigation of over 200 applications. So over 200 applications have been investigated. They are going through the assessment processes, and the responsible party should expect decision between now and the end of January. In other words, for those people who have already submitted their applications, there are about 200 applications that investigation is completed. We are conducting assessment now in terms of which decision will be taken. And from now, from the 1st of November up until the end of January, for those applications, you should expect decision with regard to those applications. And as the chairperson has indicated, the commencement date of 1st of February, at this stage, the regulator has not decided to extend that, and therefore, responsible parties who have not applied for prior authorization are encouraged to submit the application at least by end of November 2021. The reason why we encourage the responsible party to submit the application now, those who have not submitted, is because you remember when we deal with the timeline that we've got 4 weeks to decide whether to grant or to go and conduct a detailed investigation. And for detailed investigation, we've got 13 weeks, which is about more than 3 months. And that actually means you may have to suspend processing of personal information if you apply after the 1st of February for a period of 3 months. And that may impact on some of the companies. And that's why we encourage responsible parties to submit the application now and take this opportunity to submit now, whilst we have given the grace period for suspending the processing, so that the regulator can have sufficient time to finalize those applications. And lastly, as I indicated earlier on, that the guidance note on application for prior authorization did not deal with all the other seven conditions for lawful processing of personal information. And those were not covered in the application form. The responsible party who submitted the application were only required to provide information on the safeguard that they put in place, which is one of the conditions, but the other conditions it was not requested in that application. The guidance note in application form are in the process of being reviewed, and the reviewed guidance note in application form will be publicized very soon. And those responsible parties who will be applying after publication of the new application form and guidance note will then be required to, as they submit the application, to indicate how they'll comply with all 8 conditions. You can move to the next slide. And so that would be the requirement that we, but for those who currently have submitted the application for prior authorizations, they will be contacted by the people who are conducting an investigation into the application. They'll be contacted by those people to submit information on how they are complying with all 8 conditions, including condition regarding the security safeguard. So you should expect some communication, if you have not received one, from the employees from the regulator, who will request you to provide information on how you comply with all 8 conditions. We encourage you to please comply with those requests, so that the regulator will be able to assess and complete the assessment of the application before the 1st of February. And obviously, if any of the conditions are not being complied with, it means the regulator can only grant you if you have been exempted from any of the conditions in terms of Section 37. So if you do not comply with any of the 8 conditions, that will be the ground upon which your application may not be granted, unless you have been exempted from such conditions by the regulator in terms of Section 37. Next slide. That's the end of the presentation. Thank you so much, Program Director.
Thank you very much, Mr. Nemasisi, for such an insightful presentation and really assisting the public to demystify, as I said, the whole provisions regarding prior authorization. We hope this has brought the public one step closer into understanding what exactly prior authorization is and what exactly the requirements are in order to bring an application for prior authorization. So I believe that the slides can be made available on request. I see there's a lot of questions there regarding the slides, if they will be available. I don't want to waste further time. We're actually doing very good with time today. I would like to introduce our next speaker. That is Ms. Deborah Lamula. She is the Senior Manager for POPIA Compliance. Ms. Lamula, are you around?
Yeah, I know. Good day.
Are you there, Ms. Lamula?
Yes,
okay.
Thank you very much, Prof. And good day to the participants, to the panelists, and most importantly, to the members of the public that made time to attend the session. But special thank you to Mr. Nemasisi for actually laying a firm ground for the coming presentation. So I will be sharing my screen now. Share.
Thank you, Ms. Lamula. We will just wait for your computer to do the sharing. I see, yes. And I will hand over to you.
I believe the screen is now visible to everyone. If I can get
Indeed.
Confirmation on that.
Indeed,
Okay.
It's visible.
Mr. Nemasisi has laid a firm ground for this discussion, as I have indicated. What you will be receiving here now, as just from the assessor's perspective, as he has indicated already that applications have been, the assessments on applications has been conducted and it is still ongoing. So we will be touching a bit on the challenges and the recommendations. However, you'll notice that the background to these two aspects will touch a bit on the aspect that is that Mr. Nemasisi spoke to. So there are just a few considerations as a point of emphasis that Mr. Nemasisi has spoken to, which pertains to the initial considerations, what we would consider or advise the applicants to consider or take heed of prior to applying. He's already mentioned exclusions and exemptions in terms of section 6 and 7, but also other exemptions or authorizations in terms of section 38, and as well as very critically how the 8 conditions may limit, restrict, or condone the processing of personal information, albeit that the application is in terms of section 57(1). We have, after conducting this number of assessments, come to develop or establish some kind of experience. And firstly, in the first aspect, I would like to reflect on what the responsible parties or applicants, so to say, need to be taking care of. Firstly, is that they are required to answer all questions in the prior authorization form as thoroughly as possible. And why we say so, because there are compulsory sections in the form which speaks to, firstly, which of the processing of personal information is subject to prior authorization. And you are kindly, as an applicant, please select from the pre-populated categories. We experience that some applicants state the business being conducted instead of indicating the types of personal information being processed. But you also require to indicate the reasons why it is necessary to process the personal information. For example, to indicate that you perform certain functions, either in terms of legislation, e.g. where you have to be providing credit reports to credit providers. The last aspect in part compulsory in part B is that you need to indicate, is the processing of the personal information for a specific, explicitly defined and lawful purpose related to a function or activity of the responsible party. Now, this function or activity needs to be succinctly and clearly specified. The second very important aspect, and just the last one to share with you, applicants and responsible parties, is that you're required to identify correctly which aspect of section 57(1) affects the processing of information. This aspect has been really elaborated without need for addition by Mr. Nemasisi. However, we will just, as a reminder, just allude to those aspects that has been really explained. Now, the issue of unique identifiers, we have underlined under section 57(1)(a) on unique identifiers, the purpose other than the one for which the identifier was collected, because this is key in terms of whether, when we determine whether this application should be considered for prior authorization or not. Related to to this other subparagraph is the issue of linking, where you aim to link the information together with the information processed by other responsible parties. Mr. Nemasisi has already indicated on the types of unique identifiers, but what we observe is that generally responsible parties would process these types of information. However, for the purposes of prior authorization, we need to consider that these two aspects are criteria we need to distinguish whether they do apply, so that we can determine easily that you require prior authorization or not. Section 57(1)(b), ladies and gentlemen, speaks to behavior or conduct. And this is where you process information on behalf of the third parties. This aspect has also been very adequately addressed, but we just want to emphasize that This section may be applicable to any person contracted to conduct a criminal record inquiry or a reference check pertaining to the past conduct or disciplinary action taken against the data subject. For example, practically there would be reference checks for employment purposes, like where we need to apply for certain positions like directors, and where this is done on behalf of the third party by a company rendering a service on behalf of a company. This company is the one that should seek authorization. The third aspect, which according to the previous discussion earlier, is also regarded as a high risk processing, is the issue of credit reporting. Now, if we look at section 51C, it indicates that subject to section 57.3 of POPIA, a responsible party that creates credit reporting may apply for prior authorization. Now, it is vital that a responsible party considering an application under this section should make a distinction between creating a credit report versus consuming a credit report. Now, the creator of the report is the one that is normally considered for application in prior authorization. I will not delve much. I think it was adequately covered, the issue of transfer of special information, which section 57.1D speaks about. But here critically is the issue of adequate level of protection. And Mr. Nemasisi has really indicated the status of the regulator regarding this aspect. Now, we have simply drawn a few conclusions after our assessments. One is that it appears that the majority of applicants do not process information within the application, within the ambit of any of the categories of processing that are now stated in sections 57.1. This has also been part of the introduction of the chair of the regulator because it is a general concern. So now the other thing is that some applicants need not have submitted an application, but as it was indicated earlier in the introduction of the chair, perhaps this was just a matter of trying to comply, which we really appreciate. And it appears also that some applicants are not aware that the contract of employment between the responsible party and the employees, and which is normally conducted because of some employment laws, normally requires consent, and therefore the processing for this reason that there is consent becomes lawful. Where the processing is done in accordance with any other law such as the Credit Act, it appears as if the applicants tend to still think that the processing of information is conducted in terms of POPIA. However, we view that this is it's an incorrect view, as POPIA only provides control mechanisms on how this processing should take place. Now, ladies and gentlemen, we'd also like to appeal to you as we process and capture information manually at times. Some forms are handwritten and the writing is really not legible. So we request that handwritten forms should please be legible so that we avoid delays whereby we'll have to now request further information or clarity, through calls or other means of communication. Now, given what we have observed as challenges, we would like to recommend just these few three aspects. One, the applicant, whether they do the application themselves or they consider seeking legal advice of a consultant or anyone of that nature, please consider that this application should be viewed holistically, meaning that look at how you process and whether the exclusions, as we have mentioned, or whether there are other aspects in POPIA that needs to be taken consideration of in terms of whether you are authorized already automatically or you are restricted, and whether you should be exempted from processing of personal information. But as it has already been emphasized earlier, especially when it comes to assessing the 8 conditions, which are quite critical to the extent that the regulator had to amend the guidance note, as it has been indicated by our executive earlier. Remember, the application form on its own already requires you to fulfill condition 7, which speaks to security safeguards. So when we talk about eight conditions, we're not contradicting ourselves. We're just saying that over and above the security safeguards, we will be assessing the other conditions that form part of the lawful processing. So this is just a point of emphasis and a reminder. And hopefully, ladies and gentlemen, as the chair made an appeal in the introduction, once individually as a company or as a responsible party, you consider your application, just take a second look and say, check if you really needed to apply. This will be important for expediency of processing the applications. So given that, we need to emphasize, as Mr. Nemasisi also alluded earlier on, that the regulator now has a new email domain that you can access all the other applications that are required to be processed by POPIA under this email address. It is in the website. You just need to click on the black envelope and you'll find that which applications should you be corresponding with us on under POPIA in caps, compliance@inforegulator.org.za. Just to say it again, POPIA compliance@inforegulator.org.za. Thank you, ladies and gentlemen. This will be the end of the reminding points, and I'm sure this will now be followed by questions and answers from the relevant persons. Thank you very much, Prof. Snail.
Thank you very much for a further insightful presentation. We would now like to take a round of questions, possibly from the Q&A, or also if there's anyone who would like to orally ask a question. We are trying to make this as interactive as possible. You may raise your hand and we can entertain some questions. Our time is still good. Let's see, are there any questions from the floor? Are there any hands? Okay, I see it says here 2 participants have raised their hands. Just identify you. Okay, let me start with Notile Potwana. I recognize you. Notile Potwana, I recognize you to speak. Okay, maybe we have some technical issue there. Let me go over to Justine Katz. Justine, do you have a question from yourself? I see your mic is on. I'm not sure. I think we have a little bit of a technical glitch here. Justine, can you hear me? Okay, that doesn't seem to be working. Try one more. Henry Kruger, I recognize you.
Thank you for the opportunity, Professor.
Thank you, ma'am.
I have put some questions in the question and answer box, but now that I have the opportunity, perhaps I can just give the background. First of all, ID numbers are issued by the Department of Home Affairs to identify individuals. Now, they are used across the board, for example, in whether it's municipalities and clinics or in a provincial government hospital, used to identify patients. My question boils down to, we have different from a local government and a provincial government, we've got different sets that serve the same patient across the board. Can the two entities, the municipality, and the hospital link their data sets in the interest of patient care? Or is this a scenario where you'll require a Section 58 authorization?
All right, so there's a question from there. Do I have any takers from the information regulator regarding this question?
Thank you,
Let me
Prof.
ask.
I will assist to respond on that one. Ms. Kruger, I think
Thank you.
Thank you. I think it's vital to look at all grounds for lawful processing of personal information, including special personal information. So if the municipality and the national department can find a way that they can process that information, I don't believe that they need to apply for prior authorization.
Thank you for that
intervention.
Thank you for that intervention, Advocate Mohale. I see Justin Katz has written here. Hi, Professor, I could hear you. May we please have your view on whether photographs are considered to be special personal information? So that's the question there. Do I have any takers? Maybe I can deal with this question myself, right? So photographs, to the extent, that they are personal information, it must also be said that in certain instances, it could be considered special personal information, right? In certain instances, they could be just considered normal personal information, depending on, I guess, what the photograph would be depicting. And I also have Mr. Nemasisi, he wants to weigh on that. Nemasisi?
Thanks, Prof. I wanted to refer the participant to Section 26 of POPIA. It highlights what constitutes special personal information. And it's the same personal information that I highlighted in the presentation, that it's those that have been categorized under POPIA as special personal information are those like your religious, philosophical belief, race and ethnic group, trade union membership, political persuasions, health or sex life, or biometric information of data subject. It also includes the criminal behavior of data subject, but to the extent that such information relate to the alleged commission by a data subject of an offense or any proceedings in respect of any offense allegedly committed by a data subject or the disposal of such proceedings. So those special personal information are actually defined or contained in Section 26. So indeed, photograph is a personal information, as Prof has highlighted, but those that constitute special personal information are in Section 26 of POPIA. Thank you, Prof.
Thank you, Mr. Nemasisi. I saw Chairperson's hand was up as well earlier on. Chair, are you still here?
No, it's a mistake, sorry. I'm here, I'm there.
Oh, okay. Thank you, Chair. All right. We then have, let me see, Justine, that answers you. I'm going to take two more because we're a little bit pressed for time. Chrissy De Sosa, I recognize you.
Hello, thank you so much for taking my question. I
Yes.
did put it in the Q&A. My question is, as no other country that I'm aware of at least sees legal persons, so entities, as opposed to natural persons, as data subjects, does that mean that no other country can really have adequate protection in terms of POPIA?
That's an interesting question. I think I'll handle that one. I think the whole issue of, personal information of juristic persons, that has to do primarily with our constitution, the vertical and horizontal application of the Bill of Rights. And I think it happened in that particular instance that personal information could be classified also as personal information of juristic persons. I personally am not aware of any other jurisdiction that recognizes personal information of juristic persons, but I don't think that would necessarily mean that they're not adequate, because it's a completely different legal, should I say, a legal framework. South Africa is the only one that has this legal framework pertaining to juristic persons. Okay, so I've taken that one. And the last question we'll take here is from...
Just add to Prophet Varsha, if I can just add to what you were
Hi.
saying. Hi, yes, can you hear me? It's Varsha. Yeah, I think I just want to add to what you're saying is that it's just that POPIA provides quite an a more extensive protection in that regard. And any adequacy decision that the regulator will make a determination on will consider whether or not that country or territory provides an equivalent level of protection as POPIA does. So I don't think it's going to preclude other countries in any way. Thanks.
Thank you, Ms. Solal, for that intervention as well. And then the last question, because of time, goes to Pedzisai Maririmba. I hope I've pronounced your name correctly. Pedzisai Maririmba, I recognize you.
Yes, thank you, Prof. My question is with regards to unique identifiers. I had actually typed on the Q&A, but I think I may so ask. It's still a bit unclear, considering the first example that was given. You go to a retail shop, for example, and they provide their services on credit, and they collect your account number, which obviously they want to give to the bank, and so that credit can be extended to you. So that's linking of information, and now there's a third party. Would that be a situation where unique identifier is being used and you need to apply for prior authorization? If it is, it feels like that's almost everyone that is in business. So maybe just further clarity there. Thank you.
Right. Do I have any takers from the regulator on this particular question? Yes, Mr. Nemasisi, thank you.
Thanks, Prof. Prof, as I indicated during the presentation, so the first thing that you need to check is that what was the initial purpose for providing your unique identifier? And is that purpose different from the initial purpose? So if I submitted your unique identifier to a responsible party for purpose A, the responsible party then use my unique identifier for purpose B. In terms of POPIA, that has been categorized as processing that's subject to prior authorization. And I indicated that the issue of compatibility, it's a third stage assessment, which will be the ground upon which the regulator will then decide whether the purpose A and purpose B are compatible. If they are, therefore, they're in compliance with the 8th condition. One of the issues that you need to look as to why did the legislature inserted, is it section 57.3, if I'm not mistaken, regarding the code of conduct. They've realized that there might be a lot of people who may be required to apply for prior authorization. And they then put that clause that says, if you've got a code of conduct in a specific sector, and therefore there is no need for you to apply for prior authorization. So most of the people might find that because of the nature of their processing might fall under the category, under prior authorization. But if you are actually, as a sector, you decided to have a code of conduct, therefore you avoid having individual responsible party within that particular sector or industry to have a separate individual application for prior authorization. Let me give you a practical example on the credit bureau. So you might have about 100 credit bureau companies that provide credit reporting. But if they've got a code of conduct, none of those 100 credit bureau will have to apply for prior authorization because the code of conduct will have been issued and in operation. But if the code of conduct is not issued in that particular sector, unfortunately, each individual credit bureau will have to make an application, because that processing has been categorized as high-risk processing that require an authorization from the regulator. And those are the issues that you need to look at as to purpose A and then purpose B. And if you submit your information and then be used by the responsible party for purpose B by linking it with the information processed by a third-party responsible party, that actually falls under the authorization. You have to make an application. So that's how you need to conduct an assessment of your processing. Most of the time, this kind of assessment, you'll find it if you comply with Regulation 4 of POPIA, which require all responsible party to conduct what we call a personal information impact assessment. That's where you'll be able to identify the nature of your processing, and you'll be able to see whether does this processing falls under that category of prior authorization. But if it does, and there's no code of conduct issued, unfortunately, you have to then make an application to the regulator, and the regulator will assess all the 8 conditions before they authorize you to process that, continue with the processing of such personal information. Thank you, Prof.
Thank you, Mr. Nemasisi. I've just been asked by our production team that whoever's speaking, please switch on their camera. Before I hand over to Advocate Mohale in terms of the moderation, I see there's a hand up from Chair. Chair?
Yes, thank you very much. I think a takeaway from this webinar is that if a responsible party belongs to a specific industry or a specific body or specific activity, as stipulated in Section 603 of POPIA, which deals with codes of conduct, it will assist if you go to your industry and ask whether the industry intends to apply for a code of conduct. If the industry intends to apply for a code of conduct, then ensure that that industry, if you belong to it, submits that code of conduct, preferably before the 1st of February, so that you avoid applying for prior authorization. I think we need to be active as a responsible party to find out if our industries are going to be applying for a code of conduct. Thanks, Prof.
Thank you very much, Chair, for that additional comment. Advocate Mohale, are you ready to take over?
Thank you, Professor. I'm ready to go.
Thank you.
Thank you for moderating so far. Thank you. I'd like us to move to the Q&A section now, and I'm going to start with a question from Carl Forsyth. His question is, does the application of Section 57(1)(b) automatically oblige the third party referred to in that subsection to obtain prior authorization in terms of Section 57(1)(a), Roman numeral 2? Do I have any takers from the regulator who would like to answer that question?
I can try to take that.
Thank you, Mr. Nemasisi.
If you look at Section 57(1)(b), it deals with, obviously, wherein you conduct a criminal behavior or background check, as Ms. Lamula was highlighting, expanding it. So the third party, which is the company that you normally, us as employers, you will request that company to conduct the background check on your behalf. Those are the companies that will normally have to apply for the credits, for the prior authorization, but that's for conducting a criminal check. So if the question that you're asking is whether that automatically requires you to apply for compliance with Section 57(1). Remember, it's 57(1)(b) applies to a company that is be appointed by, I'll give you a practical example. If the information regulator intends to appoint Nemasisi at one of the employees, what we then have to do, the regulator will then appoint company B to conduct that criminal check, previous conduct behavior, And for that purposes, company B is the one that's supposed to apply for prior authorization. But with regard to linking the information, in other words, the question says the employee provided the ID number to the employer, and the employer then linked that information with the information that belongs to the third party. In that instance, if you look at it, the employer would not have linked anything as it is, because the employer just provided your information for purpose of criminal behavior to this other company to conduct a search for you. So they're not linking. The company that conducts the search is the one that applies for prior authorization. So what you need to look at section 51A, it's with regard to the linking of the information to an information that belongs to a third party. But the employer will not have been doing so by appointing a third party. They will not be linking that information, and therefore it will not fall under section 57(1)(a). I hope that clarifies. Thank you.
Thank you, Mr. Namasisi. That was well answered. I believe, Carl, you have been answered. Moving to the next question from an anonymous attendee. It's asking if a business does sanction checks on customers' checks. On customers, checks are done on a system that has the EU and US sanctions list integrated into it. Since RSA does not have a local sanctions list, do they need to apply for prior authorization? This is in terms of AML and anti-terrorist, counter-terrorist financing activities. Is there anyone from the regulator who would like to take it? I'm comfortable to answer. Thank you, colleagues. I think, Anonymous, that you need to refer to the exclusions or to any exemptions to see if there's anything in there that would allow this processing of information. If you go to section 6 and section 38, I believe you will find the answer there. Does anybody from the regulator have anything to add on to that one? Yes, Mr. Namasisi, I'll give you the floor.
Yes, I wanted to just add as well to say, remember if you're conducting those, so the company A applies to your company for purpose of purpose A. Let's say they want to do business with you, but then before you do business with them, you then take their unique identifier. That will be, for example, if you use their company registration number to search as to whether this company is conducting any terrorist activities. The issue that you need to check is that you're using their unique identifier, which is the company registration number. You're linking with the information that belongs to a third party. That automatically falls under the requirement of prior authorization. So you need to then obtain the prior authorization because the purpose A is for doing business. Purpose B is for you to check if they conduct the terrorist. And therefore you need to then apply for prior authorization because that falls under category A of linking the information for other people than the one that was initially intended at collection. Thank you.
I think I wonder if I might add a rider that, of course, the question of consent may well come into play if you are working with a company and you're wanting to make various checks in relation to that company. The company can agree to you doing that. So that may, in a situation where you're not something that you're doing on a regular basis, that may be, I would suggest, a possibility, but Mr. Namasisi will correct me if I'm wrong.
Thank you, Ms. Tilly. Mr. Namasisi, do you have to add to that?
Member Tilly is correct. Obviously, the consent will be used as one of the ground under stage 3 assessment when we look at the 8 conditions. So if you do have obtained consent, that's the ground upon which the regulator will then say, yes, you're processing subject to prior authorization, but you've got a consent and therefore we have the regulator will then be can grant you based on the fact that you do have a consent, and therefore it means you do meet one of the conditions for lawful processing of personal information. So indeed, consent will be very will assist you as we process this application for authorization, in that will be compliance with one of the conditions for compliance for lawful processing of personal information. Thank you.
Thank you, Mr. Nemasisi. Ms. Tilly, your hand is up. Okay, thanks, it's gone down. I'd like to go to a question from Colette Mataba. He's asking, how is such personal information handled in case where South African has dual citizenship? I'm assuming, Mr. Mataba, that you are speaking to transferring of special personal information to a country outside South Africa. Is anybody from the regulator going to take that one? Thank you, Mr. Lau.
Sorry, guys. I think I had a problem with my mic and my camera. I think if
we can hear you, thank you.
Okay, thank you. If you're going to be transferring special personal information out of the country in terms of 57(1)(d), you would have to ensure that that there are binding corporate rules, and what binding corporate rules are an appropriate safeguard which would facilitate cross-border transfer of personal information. I'm not sure whether that's going to answer the question, but I think he was also talking about dual citizenship. So if you're an EU citizen and if your information is, resides in the EU, then obviously the GDPR is going to be applicable to you. So I'm not certain exactly as to what further you require clarity on, because if there's information that's going to be transferred within an organization, and that's when the binding corporate rules would be relevant, because those would be legally binding and applicable on every member of the group within which that information is shared. If it's your personal information that's being shared from one company to another that belongs to a single group. Thanks.
Excuse, isn't it, sorry to butt in, isn't it what we need to look at in respect of the question that has been answered by Ms. Solal? In addition to that, the critical point is, the critical issue is, where is the responsible party domiciled, I think, because the obligations are that of a responsible party. So if a responsible party is domiciled in South Africa and transfers personal information to outside the country, then POPIA applies, if I understood your question correctly.
Chair, I wanted to add on what you said, to say the fact that you have got dual citizenship does not necessarily mean that you are transferring personal information. If you have got South African citizenship, it means your information is being processed by the Home Affairs in South Africa. Only if Home Affairs transfer your information outside the other country, that's where you can then look at the issue of whether it falls under authorization. But if the information is processed here, POPIA is applicable to the information that's processed here. But that information that's processed here, if it gets transferred to the other country, and that's where the issue of transferring of that special personal information may become applicable, and you have to check the jurisdiction. So, but those are issues that you need to look at, that the fact that you have got dual citizenship may not necessarily mean that you are transferring personal information to the other country. It might mean that your personal information is being processed in this country and also being processed in the other country. Thank you, Chair.
Mr. Timba, I think we have lost Advocate Mohale temporarily. Please may I request that you continue with the moderation of the Q&A. Thank you.
Indeed, Ms. Zondi. There is a question from Tumishang that I would like members of the panel to respond to. Tumishang is asking, does He's asking about Section 32, saying the exemption that applies to insurance companies, medical schemes, pension funds, etc. Does the exemption apply in respect to prior authorizations? Is this the correct interpretation? Or are all entities, irrespective of the Section 32 exemption, required to apply for prior authorization? Mr. Namasisi, would you like to respond to that question?
Thanks, Mr. I'm not sure if it might have referred to the wrong section, because Section 32 does not provide for exemption. Exemption is provided for in Section 37, where a responsible party may be exempt from some of the conditions for lawful processing of personal information. If you look at Section 32, it talks about the authorization containing the data subject, health, and sex life. That's what the Section 32 deals with. But exemption, if you're referring to exemption, you'll find an exemption in Section 37 that deals with the authorization exemption by the regulator. So the regulator can exempt a responsible party from complying with a conditions for lawful processing of personal information. But there is also what we call an automatic exemption under Section 38. And that's the one in which you are actually automatically exempted from certain provisions if you process personal information relating to certain aspect, which obviously was not part of this session. But if you look at Section 38, it provides for automatic exemption. And that's where maybe you might want to look at those two sections, Section 37, in terms of which you need to apply for exemption from the regulator, and Section 38 is an automatic exemption in which you don't necessarily have to apply for exemption, but you must put obviously all the records of all those processing which you believe are subject to automatic exemption, so that when the regulator come and conduct a compliance assessment, you'll be able to prove that why you believe you are actually automatically exempted from complying with certain conditions. Thank you.
Thank you, Mr. Namasisi. Advocate Mohale.
Thank you, Mr. Dimba. Technology got the best of us a few minutes ago, but we are back as always. Nothing can keep us down, eh?
Absolutely.
Yeah. Correct. So I'd just like us, we are over time, but I'd like us to take a perhaps one last question, and then we can hand over to close to Ms. Tilly. So I've got a question here from Monique van der Merwe. She's asking if a recruiter does criminal checks before placing a candidate with a company, would they have to apply for authorization as well? Is there anybody who'd like to take that question? Perhaps Ms. Lamula? I don't see Ms. Lamula. I think we've lost Ms. Lamula. Monique, I will take it on her behalf as I nominated her. The recruiter needs to assess whether they're doing the criminal check on behalf of a third party, and or are they doing it on their own behalf. So if they are doing it on their own behalf, as Mr. Namasisi had said, they do not need to apply for prior authorization as they do not qualify for such. And if they are doing it on behalf of another responsible party, yes, they would need to apply for prior authorization. Before we hand over to Ms. Tilly, I would just like to say thank you to my panelists and everybody for attending. The Q&A questions that we were not able to get through to will be documented and published on our website, as well as the webinar within the next couple of days. Anybody else who still has questions, please contact us, inquiries at informationregulator.org.za. Ms. Tilly, if I can hand over to you to close for us, please.
Hello, and greetings to everybody on the call. I was going to try and thank the members of the regulator and staff of the regulator who are on the call individually, but we have quite a long list, and I'm very pleased to say that. I think the regulator over the last number of years has really been trying to do justice to two quite complex pieces of legislation without really having the people on board to do it. But you know, the staff have been considerably expanded. If I may just pick just for today, Ms. Sondi and the work that she's done in bringing us together. Thank you very much for that. And members, Prof. Snell and Chair, thank you very much for joining us. Also, thank you to the people who've participated. Looking at the chat, there are a lot of really interesting and complex questions. Some questions are more easily answered, and some are frankly things that are probably better referred to Council for an opinion, because they are really quite difficult questions. But I think we will certainly answer what we can. And thank you very much for raising those questions with us. And I can only say, in agreement with Advocate Mohale, that we will try to answer all the questions we can, and we will arrange more webinars going forward with you guys in order to try and answer these questions as they come up, and as we really get into getting these pieces of legislation up off the ground and flying. So thank you. I declare this webinar closed. Thank you very much.